Hello, and welcome to the Global Antitrust Institute's discussion series. I'm Judge Douglas Ginsburg, and today our guest is Judge Ian Forrester. A brief introduction can give scope, but not justice, to Judge Forrester's career at the bar and on the bench. After training at the Middle Temple and obtaining a master's degree in civil law from Tulane University, he was called to the bars of England and Wales, Scotland, New York, and the European courts, where he chartered a career through a wide range of common law and EU subjects, including intellectual property rights, competition law, and the intersection between the two. And he did this as an academic, teacher and author, barrister, and indeed Queen's Counsel, and for the last 5 years as a judge of the General Court of the European Union, where he served until Brexit cut short his term in early 2020. I commend to all of you Judge Forrester's farewell address from the court, entitled A Valediction Forbidding Mourning, marking his departure, as he put it, to fresh woods and pastures new. It is entirely fitting that the two-volume tribute to Judge Forrester, published by Concurrence, is entitled A Scot Without Borders. Welcome, Judge, to the Global Antitrust Institute at Antonin Scalia Law School, George Mason University. Very pleased to have you with us today.
Nice to see you. Nice to participate in this intriguing adventure.
Yes, it's one that was stimulated worldwide by this pandemic, where everybody seems to have been reduced to a small box on the screen.
Yes.
Anything larger is verboten. Well, I'd like to use our time to a large degree exploring your more recent career episode as a judge on the General Court for approaching 5 years, and to ask some questions from my perspective as a judge on a court that similarly hears requests for review of decisions by administrative agencies, and of particular relevance to my interest and your career interest, competition and intellectual property matters. So let me start with a very general question that will give you some running room, and that is to say, how strict are the European courts, the General Court and the European Court of Justice, in their review in recent years of the decisions of the Commission, particularly those coming from DG Competition? I look back, way back to the Microsoft case in the early 2000s. The standard was, it seemed to be very, very lenient. The question was whether the court saw manifest error at various points in the decision that were challenged. And the 700 and some paragraphs, notwithstanding, no manifest errors were found. But I think the courts have been more searching in the last decade, let's say, than before. Is that an accurate impression from the distance?
Yes, it is an accurate impression. I think that for a complete answer, you need to go back to history and the original attribution of competence to our court. Our court used to be my court, okay, so our court. If we look at the earliest days of the creation of the European Union, was an administration which was responsible for a few rather narrow, important areas of economic activity. And the court was there, in a sense, to be fair play and to be a French-style guardian against administrative error. And that's how the treaties were drafted. Now, in the early days, you can see examples of where the court took what was then the French administrative law tradition we don't find any procedural error, and therefore we're not going to interfere with the authority's determination. Now, in other cases, back in those days, the court was quite interventionist. The Coal and Steel Authority said you can produce up to 43,000 tons, and the court said, no, should be 55,000 or 22,000 tons. So quite interventionist. In the seminal competition case of Grundy Conson, the court said, well, the Commission, and these are my words, the Commission decided to pursue market integration as an important public good, as a policy objective of the European Union. And we're not going to interfere with that. And that notion of non-interference, leaving the Commission to set its policy choices, disappeared, reappeared, and in the 90s, it was very present in a lot of judgments. Not always, there were spectacular exceptions. And then there came a series of cases which examined the extent to which the European Court would intervene even where the authority had the power to do something. For example, in the field of fines. The court is given by the treaty unlimited jurisdiction, not just control of legality, but unlimited jurisdiction to look at fines. But in the 2000s, the court used to say, the Commission has its guidelines, it followed those guidelines, we're not going to interfere. We can't interfere. And that was challenged in a case called Alcor, which I argued, and it was in parallel criticized, or that approach was criticized in the human rights case of Menarini. And in Menarini, the Human Rights Court said, this is a kind of quasi-criminal, penal situation, and therefore there has to be a proper examination of fact and law in principle complete in order for the administrative agency to have acted legitimately. So in Menarini, the court, my court, the General Court of the European Union, was reminded by the Human Rights Court that our court had to operate to a higher standard of rigor, a higher standard of interventionism than had been its practice sometimes in the past. So we can see in the past 10 years that the court has been more interventionist, more rigorous, has given the European Commission, you might say, a rather harder time. Now, at the same time, we have to note that although to you and me, the jurisdiction of the court in matters of competition is the most important, and that's what gets us into the competition record book. It's also the case that we hear appeals from 30 other agencies of the European Union, dealing with food, dealing with aviation, dealing with all sorts of things, and trademarks and plant varieties. Now, with those, some of those jurisdictions, when we get the case, we're getting it not at first instance, but at third or fourth instance. And so there we're looking at an internal board of review, an appellate body's determination. We have to decide whether the appellate body got it right. Contrast, and this is the real difficulty. When we get a huge decision in a competition matter, 500 paragraphs long, and imposes a fine of a gazillion euros, making sense of what the law is and making sense of what the facts are is a really big choice, is a really big challenge, and it's made the more so because we're getting it at first instance. In your case, you have the advantage, I think, but not always, of looking at things not at first instance, but by way of appellate review, I think. So
Yeah.
that's a very long answer to a short and simple question. And going back to what you said, are we more rigorous now in the past decade than we were? I think the answer is yes. I think the court is still grappling with the challenge of how to reconcile the power of the agency to reach determinations and the need for the court, in order to give legitimacy to the agency, to be rigorous and skeptical about what the agency has done.
I had not realized that this traced to the Menarini decision, and perhaps I should have done, because my recollection of that decision is that it was predicated on the Human Rights Court and their perspective on the essentially punitive nature of the proceedings, as say, because there's a fine to be levied. And in that case, I think the amount was €6 million. It was rather modest by the standards of DG competition. And as you may well know, that case was essentially followed or replicated in Regina versus Wigglesworth in the Canadian Supreme Court, saying that because of the quasi-criminal nature or punitive nature of the proceedings, the criminal protections of the charter must be observed. But it seems that one of the results in your court has been a much greater willingness to, or proclivity at least, to alter the amount of the fines that have been levied, which that is to say, reducing fines that DG Comp had proposed. And I think this is true in the European Court of Justice as well. The result of which must be to invite every fining decision to be appealed.
Let me let you into a dark secret. I don't think that the credibility or intellectual substance of the Commission's antitrust powers, I don't think they're enhanced by the imposition of fines. I think fines are, I have no problem with penalties. I have no problem with personal criminal sanctions. And I would actually think that Europe should go in the direction more of criminal sanctions against individuals instead of gigantic fines against corporations who have compliance policies with respect to cartels, but the compliance policies, although rigorously pursued, don't work. So I'm not a great fan of fines as a way on corporations, as a way of demonstrating the appropriateness, severity, the gravity of the infringement found in the course of the investigation. Now, I think that many of the appeals that we get, that our court, during my time, about these in competition cases, I thought that it's a bit like kind of tax practice. So our company was fined so many million, and these products were included, but that company was fined a different number of million because those products were included, and that was unfair. It is, and those cases go on. It's, I think, rather rarer for our court to say this company was fined 50 million, but we think that was excessive, and it should be reduced because in terms of gravity and duration, which are the two criteria set forth in the regulation, we think that it was disproportionately severe. In the 2000 period, in the 90s, the court pretty much declined to consider such arguments. I think those arguments are worth making. In other words, it does seem to me pertinent to gravity that a company had or didn't have a compliance policy. Why did this happen? I think that's interesting for the institution, the enforcers to know about, and I think it's also relevant for the judges to consider at the moment of appeal. Separately, there are the enormous fines imposed in abuse cases, and there, I think that the court, I think the institution is often, that the enforcer is often making a sort of normative choice. We're going to favor the platforms. We're going to favor the generic producers. We're going to favor the patentees. We're going to favor the research-based companies. Now, that choice is going to be at the end of months and months of careful examination. That's to say, it'll be there will be piles of studies, expert report, memoranda, expert testimony, eloquent pleadings, saying copyright societies are right, copyright collecting societies are wrong, and the institution has to decide, in this case, which way we're going to go. Imposing, when that's the case, saying that we favor the copyright society, we favor the platforms, we favor the generics, we favor the research-based industry, whatever it is, ain't saying that a fine is appropriate. It doesn't, to me, make the decision more or less convincing, because the instruction to change behavior is much more important for the company. And so I think back in the 90s, the level of fines which were imposed by a commissioner were a kind of testosteronic verification of the courage and energy, supposedly, of that commissioner. And it was, I experienced through practitioner. In December, if the commissioner had achieved his or her target of X million euros in fines that year, then you could maybe do a deal at the end of December, which you couldn't have done at the end of November. I don't think that really helps. I think it's better for the institution not to say 4 billion or 1 million was the correct number and defend itself there. It's better for the institution to say, this question is really important, public welfare will be better, and our intervention was was all in all appropriate. With respect to penalties for individuals, well, that's a different matter. And I would think that the campaign against cartels would be much more effective if there were individual penalties on personal infringers rather than gigantic penalties on companies where there are gaps in their compliance policy. I think that the United States has a lesson there to teach us, which is that it's penalties, personal penalties against wrongdoing, which have the best effect, achieve the best achieved compliance.
Well, it's certainly true that European and Asian companies have a much greater record of recidivism than U.S. companies.
Yes.
And OFT, was it OFT? No, yes, OFT before it became CMA. They commissioned a study by, I think, an accounting firm, which determined that the thing that British executives were most concerned about, of all the possible penalties, was personal jail time, even a very modest amount.
Yes. Yes.
I think
Disqualification to be a director. Personal penalties or personal misconduct better correspond, I think, to the needs of the situation. Now, there are people who will say we can't get juries to convict, and that is a real problem. The prosecutions in the UK and Ireland have not been the deterrent which have not led to prosecutions, and the prosecutions have not led to convictions and penalties very much. That's true.
yeah, so there's only a few cases, although a few cases go a long way.
Sorry?
I think there have been a few successful prosecutions, just a few.
Yes.
In the UK, but I think even a few go a long way in terms of deterrent.
Yes.
Effect, because most people would not want to
in the United
States and hope that a jury would sympathize.
Yes. When in the United States did criminal prosecution start having a real impact? Was that the 50s?
Well, the criminal prosecutions didn't have significant personal penalties. There was a record of a conviction of a felony, but not a fine or jail time until well into the 80s, into the early 80s. In fact, in 1985, I testified before the Sentencing Commission when I was then head of the Antitrust Division. At that point, we had very few jail sentences, and the average was somewhere about 2 or 3 months. Now, jail is routine. The longest sentence was 48 months. Recently, there's one just pending now that might exceed that. And so they get publicity, and people are much more, I think, aware of this. We just don't seem to have the recidivism problem, I think, as a result. One other datum that reflects on this is that lawyers from other jurisdictions, in particular Brazil and Europe, have told me that they have seen cartel agreements that carve out the United States.
Yes. Yeah.
They didn't draft those agreements, but they're inferring that the reason was our criminal penalty.
Sure.
So, we pursue this a little bit. Reach back, I think just before you came on the court, maybe the year you did, the Carte Bancaire case, 2015. The European Court of Justice there seemed to I would say, clarify, let us say, that DG Comp had been over-relying on objections by object rather than by effect. And of course, as with the U.S. pro se, allegations are much easier to prove, just prove fact of an agreement, whereas a rule of reason case, or return to Europe, an allegation of restriction of competition by effect is a much greater evidentiary task for the enforcement agency. So I think at that point, for about 10 years, the courts had not seen a case brought by effect. There were only cases by object. Do you think that the agency, the DG Comp, has taken the court's point and shifted? And we can talk about that generally, or in the case of perhaps of Intel, but of course the Intel statement of objections long predates the Carte decision.
I think if we just look at procedure, I think there's a tendency in the administration, in the European Commission, and also maybe sometimes in the court, to write in the blackest possible terms and about a controversy or a problem. And I think that it's easier, or it's tempting, to say all these arguments are that all these defenses, these excuses are ridiculous and we don't even need to consider them. But in any event, we will consider them. But now having considered them, this is a by object, and therefore we don't need to eliminate every stupid argument and every implausible argument that is made in there. Now, I think that the reality of modern competition law is much more carefully balanced than that. And I think that decisions would be more convincing if they were written on the one hand, on the other hand. Now, when the institution has to describe in public, in writing, what it has done and why it has done it, the tendency must be to be as complete as possible. You don't want to run risks. You want to be comprehensive. And so there's a tendency for the institution to include everything, including the things which are really not so serious, but may be part of the context. In the context of pay for delay, you can make, that's where the patentee has got in Europe a network of patent entitlements, patent claims, which are granted centrally, but courts locally. So you may be, if you're the patentee and it's pharmaceuticals, if it's a successful medicine, you may find yourself in 7 different courts and in different member states, and you don't know that you'll win in Germany and lose in France on the same question. So, of course, you want to settle, and you want to settle on any reasonable terms. What's wrong with that? Avoiding litigation. Yeah, of course, everyone wants to avoid litigation. But what if the infringing party, the generic company, instead of paying the patentee a penalty to walk away from the court case, actually given a financial incentive? Well, doesn't that look like bribing the opposition to walk away from the marketplace? Many of these cases came up, and I was involved in a number of them. So as an advocate, but not at all as a judge, I looked at the pay for delay cases thinking, this is being presented in a rather oversimplified manner. And I don't think that the analysis is helped by expanding the category of infringements by object, where the effect doesn't need to be considered. I really don't think that that kind of approach, kind of labeling approach, a really very delicate legal and economic question. And I find the theoretical debate in court and before the institution about whether we need to justify it or not very satisfying. I would rather look at the underlying reality and what are the circumstances, pro and con, and be more guided by those circumstances than the simple label, by object infringement. And I think it's a kind of term of abuse. I don't much like by object infringement, a way of concluding a big case. In reality, the Commission is so thorough that it gives lots and lots and lots of information about why the effect is competition. And I would rather look at those effects instead of debating in a kind of artificial way whether we need to consider those or not.
Well, it's understandable from the point of view of the enforcer, and indeed our Federal Trade Commission over the course of a decade brought cases, and finally when they go into the Supreme Court was trying to establish a per se condemnation of a reverse payment. And the Supreme Court fortunately rejected that and said it was a rule of reason matter, although they gave the misimpression, I'm afraid, that some compensation much in excess of avoided litigation costs was inherently suspicious. Well, if you have a patent on which you have revenues of $1 billion a year, and there's even a 3 or 5% chance of it's being invalidated, it's worth a good deal more than the avoided litigation costs to settle. That doesn't reflect a lack of confidence in the patent or its validity whatsoever. But the lower courts were left to work that out, and it's still a work in progress. If we could talk about Intel for a moment. I would
Say again?
The Intel decision, we can talk about that for a moment.
Mm-hmm.
One particular passage I always found amusing in that case is the paragraphs that they're not quite together, but they're very close in the opinion. One saying that the purpose of this exercise of the competition laws and articles of the treaty are the point is not to preserve competitors, but to preserve competition. And then a couple of paragraphs later say, in essence, but of course, in order to have competition, we need to have competitors, evincing a certain sympathy for preserving them. But there's another more central part of the case that I really would prefer, would hope you could clarify for me. The decision, the Commission's decision in Intel, the 2008 decision, which was the second one, never said by object. But the thrust of the decision was that yes, we will look at the restrictions, in that case, very substantial loyalty rebates. We will look at the restrictions and determined, the Commission determined that, I'm going to quote, by their very nature, they were capable of restricting competition such that an analysis of all the circumstances of the case, and in particular, an as sufficient competitor test, were not necessary. Now, of course, the European Court of Justice sent it back to the General Court to explore the questions that the court and DG Comp had not allowed Intel to develop in its own defense. That seemed like a sort of a halfway house decision. It's somewhere between the by object, which was not alleged, and by effect, saying, well, it's by effect, but the effect is so manifest, or the potential effect, that we really needn't go into it in great detail. And we're just going to do so. We're going to go into the as efficient competitor test as a matter of grace, but just to provide greater certainty. So what was going on? I mean, it really is unclear to an overseas observer.
Well, a health warning, first of all. I was one of Intel's many counsel at one stage in that battle. But that was just for a limited period. I do know a little bit of the underlying question. What's going on in that case? I think part of what's on is an awareness of two conflicting principles or phenomena. One is that since Hoffman-La Roche, it has been the belief that fidelity rebates granted by dominant players create loyalty and are therefore bad. And that, so that's one, there's a very strong strand. There have been opportunities for courts to depart from that. British Airways, Virgin, there have been a series of cases where the principles or the doctrines which have been adopted in the early Hoffman-La Roche vitamins case. There have been opportunities where that policy, that practice, could have been attenuated or moderated. The Court of Justice said, no, we're going to, and I'm exaggerating and oversimplifying, we're sticking with the established principle. So that's one trend. Europe has this quirky notion that it's anti-competitive to be too competitive if you're a large player, and looking for loyalty among your customers is not bad. But on the other hand, European competition law is a competition law in the world, and the world generally favors the granting of rebates and the encouragement of and offer lower and lower pricing. So I think what happened in Intel is that the Court of Justice decided time for a review, and the Intel judgment, which has been the Intel judgment of the General Court and the opinion of the Advocate General, the judgment of the Court, that now constitutes, that has put the pot back on the boil, and we shall see in some years' time, I'm afraid, 15 years after the facts of the Intel case, we will see where we end up.
The Intel case at this point is more than 15 years in the making.
Hmm?
The Intel case itself is more than 15 years in the making.
Yes. I would have imagined if it goes to a decision by the Court of Justice, we'll be 2022 before that judgment comes down. But I hope that when that judgment comes down, we have a rationale that is not too complicated or sophisticated. I don't think issues in the Intel case needed all that immense amount of economic data and those hundreds and hundreds of paragraphs. I think the issues in the Intel case could have been explained very much more briefly. But because the Commission writes defensively, because courts write defensively, we have a huge apparatus. I like the fact that the Advocate General's opinion was rather short. I like the fact that the key paragraphs of the Court of Justice were rather short. So I think that's maybe an opportunity for the General Court to restate the principles in an intelligible way without it being desperately complicated.
You're the optimist.
Yeah.
All right, so then, let me ask you then about this case of ZTE against Huawei, in which the European Court of Justice laid out a code of conduct, a very legislative-looking document.
Yes.
For how a patent holder of a standard essential patent should proceed in in demanding royalties from an implementer and how the implementer should respond and all of that. It seems so uncharacteristic for a court.
Yes, indeed. I have seen as a practitioner, and I've also seen on the court, the enormous difficulties, controversy, greed, capitalism, unreasonable conduct, insert your own words, immense controversies about what royalties are appropriate for patent essential,
standard essential.
Exactly, standard essential patents. And I have been, as a lawyer, I've been on both sides where the patentee says, I want a gazillion cents for every product that is produced, and the licensee says that's grotesque, that's unreasonable, that's going to put me out of business. And one side says, well, in that case, you can't do the license. No, well, that's going to involve chaos. And so the use, the abuse of standard essential patents and the extraordinary controversies that licensing disputes can give rise to made a real need for what you might call a roadmap to guide parties to an adequate conclusion in a dispute about standard essential patents and FRAND and so on. And I was quite pleased to see that the court had been so interventionist in that case. I don't know whether I don't know whether it's right in every particular, and I'm sure that some of the choices made might be improved. I thought it was, although bold and I thought it was really pretty good for the court to say, look, guys, we can't go on like this with paralysis threatened every 6 weeks to European industry. We're going to have to establish a set of guidelines, a set of principles which will assist parties in reaching a conclusion, as opposed to taking two extremes, a gazillion on one hand and nothing on the other. We're going to use some guidelines, and I thought, wow, that's interesting.
Well, I've described it as the second best solution, the first best being to say this is not a competition issue, the contract courts will sort it out. But if it is going to be a competition issue, I agree that what the court did was very useful. It just wasn't very court-like.
Yes, yeah, well, I'm not disagreeing with that.
So there's a mystery for those of us in the common law world from which you come, and having bridged the channel and penetrated the fortress, perhaps you can explain it. And that is the role of the Advocate General. I mean, it does seem from looking at the record of Niels Waal, from Giovanni Petrosella, it does seem that the AGs have a degree of specialization in their subject matter, which raises interesting questions about a specialized tribunal, such as the UK CAT. But it also raises internal questions about how influential those recommendations from the AGs are and are meant to be. Where does this institution come from? Is this also a French invention?
It's indeed. The Advocate General was imported to the Court of Justice from the French Republic, and the Advocate General role is that of one who wears the same robes as the judges, who comes onto the bench through a separate door sometimes, and who has a different status. In my view, to be an Advocate General in Luxembourg is the most fun job which any European lawyer could have, because
I can see that, yes.
You can work in your own language and French, and you produce your own opinions, and if the court doesn't like them, then the court will depart from them. If the court has difficulty in reaching a conclusion because there's two strands, and if we go that way, problem of consistency with those judgments, we go that way, there's these judgments which are difficult. The Advocate General is the one who puts to the court, well, now, we're at a fork in the road. You can go that way, and if you go that way, it's good for the individual, it's good for reuniting families, and it corresponds to this provision of the Charter of Fundamental Rights. But on the other hand, as the member states noted in the preamble, so that will be an alternative route. And the court may, and in some cases does, just say very briefly, here's the result. And the Advocate General's opinion is there as a sort of comprehensive review of where things stand. So the Advocate General doesn't opine in every case, only where it's thought to be necessary. And yes, there is a degree of specialization in the sense that the first Advocate General assigns cases. In my court, in the General Court, where there usually is no Advocate General, although we can appoint one, the cases come by vote. That should say automatically. It goes to the first chamber, to the second chamber, third chamber, and then by the next judge in turn. But the Advocates General get cases assigned by specialization, interest, and so on. And so in the cases about whether the wearing of the Islamic veil could be prohibited, and in what circumstances, by employers, there were two female advocate generals, Cocotte and Sharpston, who were given the job of writing in parallel independent opinions. And they came to different conclusions. The cases were slightly different, but contrasting them is very, very interesting. So I have no doubt that the jurisprudence of the court is richer for the availability of the Advocate General's opinions. Sometimes they recite what's obvious, but sometimes they really are lively, intriguing, juicy morsels.
Well, we don't have anything remotely like that. Well, perhaps in the sense that the Supreme Court can call upon...
When the Solicitor General comes to the Supreme Court.
Yes, that's what I was thinking. The Supreme Court can call upon the Solicitor General for the views of the United States when it's not a party. Even when it's not a party.
Yes, recently, with respect to the replacement of the U.S. Attorney for the Southern District, I think the U.S. District Judge appointed former judge.
I think that's a different matter. here in Washington, the district judge who has had the prosecution of Michael Flynn in front of him
Yes.
appointed a former district judge from New York, from the Southern District, to give him an opinion.
Yes.
It was a rather peculiar exercise because that former judge had already written an editorial in the newspapers expressing his opinion.
Ah.
So, and then if you up here saw that yesterday, my court issued a writ of mandamus,
Yes.
instructing the judge to terminate these proceedings. I am often asked by students and others about the role and importance of oral argument in the U.S. Court of Appeals here in Washington.
Mm-hmm.
And I've been told that by practitioners in Europe that the hearing that occurs at DG Comp is nothing like that whatsoever. It's not really comparable. It's addressing an essentially silent body of bureaucrats who will then write a report for the decision maker. But when it gets to the general court, when it comes to the general court, my impression is that the oral arguments are rather much more like they would be in my court in the US or in the high court in the UK. Fair enough?
Yes. I have strong views on the subject of oral argument. I think that the visible part of the process of rendering justice, and in my view, a really important exercise in demonstrating to the justiciable, the citizen, that the arguments are being considered. And there's a cultural problem in Europe, which is that in many continental European countries, for a judge to say, come on, you're really arguing to me that
Sounds familiar.
surely that's impossible to reconcile with what we said in our judgment. No, my lord. Now, that sort of debate or that sort of discussion, absolutely routine in North America, in Ireland, and in the United Kingdom. But it is not routine in the 26 member states of the European Union, including Europe. And so in every case I sat in, I always asked a question, each one, to show that we were awake and listening and understood and prepared. And when, especially when they were British, they would treat me as they would in Britain. Judge Forrester, no, you were mistaken, We would have a quite vigorous back and forth. And one of my colleagues afterwards, when we went backstage, said, Ian, it's always interesting to you talking to an English UC. And I said, well, does it embarrass you? Is it inappropriate? Because, yeah, we did get quite heated, but we were polite, but we were giving strong views. And he said, oh, no, I'm not complaining. But if I did that in my country, I'd be subject to judicial discipline, because the judge would be revealing by his question her sentiment as to the way the case goes, and the judge should not do that. And my answer, of course, is I'm testing a proposition. I'm not saying it's correct. I'm asking the counsel to comment on what would appear to be a contradiction between what he said and page 17 of the decision. Now, other judges have the approach that yes, we can ask questions. It's a question like on page 17, you say 7.3 million, but then on page 15, you seem to say 16 million. Now, is that a mistake, or please can you reconcile that? That's a question. Whereas a Brit will say, will want to debate the merits, will enjoy it. Now, I say in my writings and orally to my colleagues, questions from the bench are not rude, they're not impolite. They're a manifestation of the judge's interest. The judges are awake, the judges are keen to understand what's going on. So it's not being, it's just a question in order to verify where things stand. So I tried, and all the Brits, there have been, I think, 11 of us, 11 Brits have been members of the court since 1973. And I think all of them have contributed to the development or the maintenance of oral argument involving a debate with the bench. And I think that even those who feel maybe the Brits go a bit far, maybe Forrester is a bit too peggy from time to time and too violent, the concept of a debate between the bar and the bench, I think, is now firmly established as part of the.
Well, when I was in Luxembourg and speaking to some of your colleagues, I don't remember if it was last fall or a year ago. I mean, to lose track of time with this pandemic. But a couple of them at least commiserated about not only the prospect of losing you as a colleague, but also of losing the interest that you bring to oral arguments. And indeed, losing the benefit of British counsel in many matters, yes. Because they are among the liveliest and most penetrating. Yes. But I also think that it serves the court to, when a judge through discussion with the counsel can narrow the issues through what might be clarification or a concession wrung from counsel. And that serves everybody's interest.
Yes. Yes. And it's also important to make counsel prepare properly. Sometimes, sad to say, counsel have appeared who were not good enough and had not really taken the time to prepare as well as they should have. And I hope that when that person comes back, that person will not be underprepared a second time.
I think when there isn't colloquy from the bench, there's a temptation for many lawyers to read their arguments.
Yes.
Which can be quite deadly. When I was a clerk for Justice Marshall on the Supreme Court, we were hearing a case, the court was hearing a case in which the Attorney General of New York, through an assistant, was presenting, and she read her argument. And Justice, not Chief Justice then, but Justice Rehnquist said, so-and-so, are you familiar with Rule 44 of this court? And of course she was not. Why would she be? And he said, well, it provides that arguments that are read are not favored. Of course, now she was at a complete loss. So it was a nightmare for everybody. Yes. It would have been better to let her just read, I'm afraid. But it is deadly. It really is. Well, if I may, this is well-trod ground, and I hesitate to leave you without the opportunity to retread it. the impersonal nature of the court's decisions, of a piece with impersonal hearings, let's say, in which judges express no views, is manifest also in, of course, the absence of any dissents.
Hmm.
A few years ago, I asked a member of the European Court of Justice, and then a week later, when I was in London, a barrister there, a prominent barrister who practiced a good deal in Brussels, why that was. And I was given literally the same answer as though they had practiced it. This is now perhaps 10 years ago. And the answer was the union is too fragile. It struck me as surprising, let us say.
Yeah.
But then I read something of yours about the problem that it might arise when a decision runs against the government of some, let's say, one of the newer members, and the newer members' judges dissent. And how would the judgment be then treated in terms of enforcing it in that country? Is that, do you think, still a fair concern?
I am. I'm more sympathetic to the. I better understand the problem than I did when I went on the court. We produce single judgments which are drafted by the juge rapporteur who gets input from colleagues. Sometimes it's one deliberation and there's consensus. Weeks and you're home. Sometimes it can take months of argument in order to reach consensus. Yeah, it may take end deliberation meeting in order to slug through all the questions that are there and reach conclusion. And the juge rapporteur and the president of chamber have to produce judgment which corresponds to the wishes, preferences of the chamber, comma, even the reluctant. In other words, a majority opinion. The great majority are not majority, they're unanimous. Now, in a unanimous opinion, there will often be tweakings and negotiations a judgment which is acceptable to everyone. In technical matters, competition, state aid, trademarks, I would be happy with these days. I would be happy with a sometimes a dissent, because it may make the judgment clearer, and it may make the development of the law go a bit more cautiously. If we draft in a what I call winner-takes-all way, we may give the impression that a really important and very sensitive and very difficult determination by the authority, bold, and where we're saying, yeah, that's okay, but gee, wow, that's okay in this case. We may, if we draft a judgment in a winner-takes-all way, we may give the impression this is dead easy, there's no problem. Mm-hmm. And a dissent may just be a flag telling the authority, careful, careful, this is not so obvious. So in our court, I wouldn't be troubled by the creation of the possibility of dissenting opinions. The Rights Court has them. They would be rare, and I don't think it's that political. In the Court of Justice, I think the majority view is still we go for unanimous, anonymous, almost opinions without dissents. Although it's true, sometimes the way in which cases are drafted, judgments are drafted, involves saying in paragraph 81, X minus 3, and in paragraph 95, X minus 4 plus 1. Is there a different, and people pick it up and look at it and take it and parse it in a very sophisticated way, which may actually just be a bit misleading. So, long answer to a question. I would say that I wouldn't be troubled by dissent in dissenting opinions in the general court, but there isn't a consensus for them, at least at this stage in the court.
It's some consolation to think that disagreements among the judges in the chamber may result in at least some accommodation
for sure.
in the opinion. If it doesn't,
sure.
it doesn't create actual tension, but instead just simply serves perhaps to narrow the decision or
yes.
to omit something gratuitous.
Yes. Whereas in some cases in the Supreme Court, there are 2 or 3 judgments, and it's not easy to see what the court has said, or it's easy to see that the court was not in agreement. In my court, there is a judgment. Now, there may be tweaks, there may be inconsistencies in the text, there may be errors in translation, or not errors, but inconsistencies in translation. There may be errors in that. But there is an outcome which is there, and the dispositive is here. But I know that sometimes in the United States, judgments in the Supreme Court are really pretty obscure.
Well, like most law students in probably the English-speaking world, I read many a judgment of the King's Bench and others in which there were 3 opinions, and it was left to the reader to figure out what the holding of the court was, and to the imagination of counsel in later cases. And I only recently discovered, 50 years later, the rule against orality, in which there was actually a strongly enforced norm that the judges not confer at all before they rendered those opinions, which they did orally. They would hear the arguments, and without leaving the bench would render those opinions. That was considered an important norm against combinations and conspiracies and in distortion of the law, I guess. It's quite surprising. Ian, you've been extremely generous with your time, and it's been absolutely fascinating and great to talk with you again. It's been far too long since we've been able to get together with this pandemic. I was hoping to have been with you, well, wherever you might have been in June. Originally, I was hoping it would be in Luxembourg, but then in London. But
my cellar awaits your convenience.
Don't tell us don't leave us without telling us, if you can, what's next.
For me?
For you.
Well, I don't want to retire because people who retire normally die. I found the court absolutely fascinating, utterly extraordinary as a place. 24 languages, 27 other nationalities, completely different backgrounds, public officials, diplomats, ministers, teachers, not many practitioners, a few practitioners, a huge range of different personalities, ages, people who grew up under communism, people who are 40 years younger than me, people who are fantastic linguists, people who are strongly characteristic of their country's traditions, and people who are very much internationalist children of Europe, and threes or fives or 15s sitting together, forced to reach an agreement on legal questions. That's wonderful as a place to work. So I would like to continue in the trade of being a lawyer, and I would have given you a clearer answer if it hadn't been for that pesky virus, which has made a big mess of all our plans. And so I'm waiting here for the metaphorical clouds to part and for travel to be permitted. And then I hope I'll have my next statement, and I'll let you know what it is.
Is it permissible for a former judge to appear before the European courts?
After 3 years.
I see.
To appear. You can think about European law even the first day that you leave, but you ought not to sign or argue before the court
Yes.
until.
Well, I look forward to the announcement whenever it comes as to where we can find you next. But wherever it is, I will find you. Until then, again, thank you so much, Ian.
Very nice to talk to you.
Really been a pleasure.
I look forward to the next time.